Hey Lee, welcome back onto the Captain's Vlog. It's very good to have you here again. So this is the second video, and some of you may recall that we did an earlier video. And we did that video in response to some of the announcements that we were seeing in the Salesforce community around layoffs coming out of Salesforce. And then since then we've seen the same awful news coming out of lots and lots of other companies, particularly in the tech sector. So a bit of time's moved on since the first video. So in the first video, we tackled some of the basic issues or premises around redundancies. And now that we've moved on a couple of months since that first video, I think people are in a different position now. So folks have started to receive these agreements, and they're probably scratching their heads wondering like what comes next and what they should do next. And so Lee, thank you for coming onto the Captain's Vlog to help us answer some of the questions that these people may have at this point in time. And it's probably worthwhile just having a chat to you about what happens next and what they can expect from this point onwards.
Yeah, absolutely. So obviously in the tech sector, we are still seeing, aren't we, a lot of layoffs, a lot of big, the bigger organisations, the well-known names, unfortunately laying people off in large numbers. And as you said, that does lead to an obligation, particularly in the UK, to consult first of all over the redundancies. They'll be dealt with as, people call them layoffs, but they're dealt with effectively as redundancies.
Yeah.
So there's a duty to consult, and we have seen that some of those sort of larger processes are now drawing to a conclusion. There's a requirement to consult for a certain number of days, etc. So you've got to get through that process as the employer and as the employee, because you feel like you're a bit kind of, you can't do anything until the end of the consultation process. But I think now with most of them, we're kind of beyond that.
Yeah. I mean, it's quite shocking actually, because when we first started talking about it, I mean, this whole thing was triggered by the fact that I'm ex-Salesforce. I spent nearly 11 years there, and a lot of my friends who I work with had been affected. So it was quite unusual for me to see people who'd been in a role for a very long time, who had spent many years adding huge amounts of value to the business, to be at risk of redundancy. And I've not seen that before. I mean, I'm old enough to have been around back in 2000 when the dot-com bubble burst, and then it was blood on the streets. It was horrible, really. But you could see why they were laying people off, because the capital markets had dried up, funding for startups has started to dry up, and a lot of these companies that had been funded to go off and build these dot-com businesses simply weren't delivering on their promises. So something had to give, and unfortunately the consequence of that was a lot of people were laid off back then, and we're seeing that sort of same thing repeating right now. So I have some questions, Lee, if that's okay. Can I just go through them with you?
Yeah, absolutely.
So the people that have been affected, that have been given these settlement agreements, I mean, for the guys that haven't seen one before, like, what is a settlement agreement, and what should they be expecting from that?
Yeah, it's a very good first question. So following the consultation process we mentioned, a lot of these businesses will want to see the process through pretty quickly. So where you've got kind of a termination of employment, you've potentially got some legal issues cropping up. So there could be, for example, claims, unfair dismissal, redundancy pay. There could be various claims, and a settlement agreement is there to benefit the employer, because what it basically means is once it's entered into, the employee will not be able to bring those claims. So it's a clean way of sorting out a sort of termination of employment. And of course the quid pro quo is the benefit for the employee is speed, but also they get certain payments in consideration for agreeing to move on and not bring any claims.
Right. And in the previous video, I'd mentioned that this had happened to me, back when the dot-com bubble burst, and I was quite sort of young and naive, and I think in hindsight I probably would have done things differently. I probably would have spent more time reading that agreement. For a start, I think it was almost sort of like the accepted wisdom at the time, which you get the agreement, you sign it, and you kind of move on. But now that I'm older and probably just a teeny bit wiser, I would probably question what was in the agreement just for my own benefit. So I mean, on that basis, what compulsion is there upon the employee to sign the agreement? I mean, and can they challenge it? Do they have to agree with it?
No, they don't have to agree with it, absolutely. So like anything else, it's an agreement, so it depends on both parties reaching agreement. So ultimately, But the main driver of all of this is that the employee takes a decision that actually it's in their interest to sign it, because A, they've sometimes got another job already, or B, they've got a plan, they want to move on, and C, they get tempted by the money on offer. So usually the money that passes under the settlement agreement it can often be more than the tribunal may award, even if they decide to bring a claim arising out of it. So, it depends. I mean, sometimes I have deals where employees come to me, they're not actually being paid an awful lot. I've got one deal at the moment where the employee is being paid less than their notice period and then no further payments. So, it does depend on the deal. I think with a lot of these tech layoffs, there's a very standard formula. So you'll find that basically they're improving on what we call statutory redundancy pay, which is relatively low. So they're kind of improving on that. They might be paying people in lieu of notice, so you get the benefit of not having to work your notice and you move on, you get a further payment. And there's various other things that can go in there to make it a relatively attractive deal for the employee to sign up to.
Yeah, I mean, I think so. The tech companies are well known for giving more than what is the legal minimum and that sort of thing. But I think maybe the questions come up when people discover that somebody in a very similar role to them, with a very similar tenure, may have gotten more or less than they have, and then the question is, well, how do you decide to offer them more and offer you less, or offer somebody else less and you more, and that discrepancy, and I think this is the kind of thing that triggers some people sometimes. Is it worth investigating, like why that might have happened, or is that just a futile exercise?
Well, I think the key thing is that there's always a confidentiality clause in these agreements, as you might expect. So, but there are various exceptions. You can't keep things confidential for certain other reasons. But particularly, I mean, the deals themselves are usually fairly standard in tech businesses. So most people do know that they're going to be paid a certain formula. There could be different treatment. You might find some people are being preferred. They're not having to work the entire notice period, where some people are working some of the notice. So those nuances, they can cause people to think, I wonder if it's worth a challenge. And that's where you need to take legal advice anyway to enter into the agreement, because that's a requirement. It has to be signed off by a lawyer. And at the same time as having that discussion, sometimes employees say to me, do I need, what would be the other option, and is it worth it? So I always kind of explain, go through what would be the benefits of doing something different, maybe challenging something or bringing a claim. And in some cases there might be things like, I don't think the treatment's been fair, the selection exercise has not been done properly, I think I've been discriminated against. So there are certain cases where the employee decides not to proceed and to go down a different route.
Mm-hmm. I mean, that point of getting legal advice, if that agreement is just fairly clear cut and you just agree with it and it's all fine and you're happy with the settlement, do you even need legal advice? Because that's going to cost money, right? So could you, since money is a factor now because you're about to lose your job, can I save some cash by not involving a lawyer at this point in time?
The answer to that is no, because your employer will require you to take the advice, because that's the thing that protects them against claims. If they've been advised by what's called a relevant advisor. It can be a trade union official, but very often it's a solicitor. And provided the solicitor has advised them on what they're giving up, it's a statutory protection really. And provided that the lawyer signs the agreement, then the agreement's legally binding and effective to settle the claims. Yeah. That's when the employer is happy, they can pay the money. So the answer is no, you will need to take the advice, but the slight sort of carrot and stick, if you like, is that often the employer will contribute to or pay the legal expenses. Okay. So there is so if it's a straightforward one, then usually that contribution kind of covers the advice, so there's nothing to pay. If more advice is needed, if people are sort of saying, well, actually, I'm not entirely sure, or let's say the agreement, a few of the clauses need to change, it's not in fact, there are certain bits of negotiation that need to happen. If that happens, then obviously the fees will be more, and the question then is who pays them. Okay,
that's interesting. So you need a lawyer, pretty much, end of. So going back to my own personal experience from back in around 2020, which it sounds like yesterday, doesn't it? It was a very, very long time ago now. Not 2020, around 2000. I've got that completely wrong. Yeah, it's a very long time ago. I needed a lawyer because I needed someone just to look over the agreement to make sure that I was signing off on the right things. I just went to the nearest high street lawyer, had a chat to her. Her stock in trade was helping people buy houses, so she was a conveyancer. But at the time, I was quite naive. To me, all lawyers are lawyers. And I've since discovered or learned that, there are good lawyers. There are lawyers that are more relevant to what you're trying to achieve. And I guess the question to you, Lee, is how do you go about finding the right lawyer or the right law firm to help you with this?
Yeah, I mean, it's a good question because obviously from the inside I can see that lawyers are all specialists and, we all specialise in certain things. But from the outside, looking in, obviously you'd think, well, I just need a lawyer, that's fine. I don't really mind what you practice. But you should definitely go to an employment lawyer, someone who specialises in employment law. And you can find them. There's something called the Employment Lawyers Association, ELA. If you Google that, you can go onto a directory, and everyone on that directory, and it's free to access, will be employment specialists. So that's one, one thing. The alternative is to ask around for recommendation, is what a lot of people do, or just Google and find someone in your local area that specialises in employment law. Those routes are all pretty good, but I think a personal recommendation is often what people do.
Yeah. Then you can sort of bounce off each other's experiences, can't you? And you get some sort of secondary advice of the person that's kind of recommending the professional because they've usually dealt with them themselves. So
yes, absolutely.
So I mean, if I'm looking at my agreement and I feel particularly aggrieved about something, and I want to challenge it, what's the best way forward? How should I do that?
Yeah, that's a good question. So I think that the way to do, it depends on what the thing is. It might be capable of being resolved. So, for example, if the money's not quite in the right ballpark, there's often a discussion to be had. There could be some shares that have to go back. There might be some payment for those. I've had clients who have been sort of basically really unhappy that they've been selected for redundancy in the first place. So there's internally they could challenge that. They could raise a grievance. They could have a meeting with a line manager, with HR. But at some stage, I think a decision would need to be made as to whether to take the deal, or whether to pursue things internally, and challenge that part of the decision making.
And what would happen in general if you did challenge something? Do these things, can they conclude in weeks, or can they end up taking months, or is it like Hollywood where, things can drag out for absolutely years? I guess it's a piece of string answer, isn't it?
I think, most things. Most things are capable of being sorted out with a sensible discussion. So if I get instructed on a settlement agreement, I'll often pick up the phone to HR or the company or whoever's dealing with it and just say, can we just have a chat about these issues? Often you can kind of nip things in the bud there, particularly if it's about the drafting of the agreement or something in there, particular term. So that's a good way to do it. Sometimes it's more appropriate for the employee to actually raise things themselves, kind of internally, without keeping the lawyers in the background. Not everyone wants to kind of go in full pelt with the legal situation. So it depends on. I judge each sort of situation on its. What's the appropriate way forward to get the best deal, to get the best situation out of this. Some cases do end up, in a long process that you mentioned, like an employment tribunal or something like that. Not many, and I think you'd only do that under certain conditions. If you felt particularly strongly about the way you've been dealt with, or if there's discrimination, something that needs to go before to a panel to decide. So there are some of those cases, but in most cases, matters do reach an agreement at some stage.
Okay, thank you for that. And so, okay, let's say I've already found a job. I've got a job lined up. I'm going to start quite soon. Do I still get the settlement?
Ooh, it's a good question, isn't it? You may not. You may do. So usually these settlements, if it's a standard formula, payable across the board. So everyone's being laid off. And we've consulted, we're now offering this deal. Usually, having another job is not an issue because let's face it, you're being made redundant. The employer is probably expecting people to go out and find another job, and in fact, will probably be quite pleased if people did. So usually, that's not so much of an issue. Sometimes you have individual deals that are negotiated on the basis that the employee has put forward the position that they're on the job market, they're going to be out of work for, let's say, 6 months, 8, 9 months, 12 months, whatever it is. And so if the deal is negotiated on that basis, if it's compensating you for loss of earnings, then quite often the employer will include a clause that says you warrant that you've not got another job, or you've not got an expectation of another job or a job offer. So you've got to think of the word, you've got to look at the wording quite carefully in those situations, because obviously if you have got another job lined up, you shouldn't be agreeing to that warranty. And if you've given a false warranty, the employer can demand the money back. So you've got to be a bit careful with some clauses like that. If it's a standard deal, the employer doesn't care whether you've got another job or not, and/or is quite pleased, not a problem. But with some of the deals, there is that warranty in there because the agreement's reached on a different basis.
Okay. Oh, that's really interesting. So, these companies that are like laying folks off, if you look at their job boards on their websites or on LinkedIn or whatever, they're still advertising for roles and positions and jobs and so on. And shouldn't they really be offering these up to the targeted list of people that are looking to lay off first? And in some cases, you can argue quite strongly that actually that role that's being advertised, I could do that. Might need a bit of cross training or whatever it might, but at some point soon, I could do that. I could do that job. So why aren't they offering it to me first?
And I mean that does bring up an important point. So certainly, if they're looking at layoffs or redundancies in law, there's a duty on employers to take to offer suitable alternative employment if it exists to affected employees. So certainly, as part of the collective consultation process, there should be a discussion about, well, what do we do about jobs that are being created? Whereabouts are they being advertised? Is it appropriate to recruit from outside when we have a whole pool of people here who are company employees who are going to be losing their jobs? Should we not ring fence those jobs for the people affected by redundancy? And that's often what does happen. It can affect the fairness of a dismissal. So if you're being dismissed, your employment's being terminated because you're redundant, and the employer has acted unreasonably in some way, that could give you an unfair dismissal claim. So if they haven't offered you any suitable alternative employment, and actually some does exist in the organisation, then that can give you an unfair dismissal claim. Maybe something to pursue with them. It could increase the compensation.
Okay, thank you. I don't have any more questions. I guess last question: are there any sort of general hints, tips, or guidance that you can offer?
Yeah, I think I would certainly absolutely try and find the right lawyer to advise on the agreement. An employment specialist, someone who knows what they're doing. There are lawyers who will take on a settlement agreement who, as you say, do conveyancing or buying and selling houses, because all they're thinking is they'll just sign the piece of paper and the employee will go off and be happy. There's no issues. But of course, they haven't spotted some of the nuances of the wording and the situation. So I would get someone who specialises in employment law to look over the agreement for you and give you advice. Yeah. You'll often have questions. Have they done this properly? Am I better off, refusing to do a deal, bring a claim? Is it worth negotiating? Can you do that for me, or will I do that? So those kind of questions are better answered by an experienced employment lawyer. So that's the piece of advice I would give. I would give that, wouldn't I? Because I am an employment lawyer, but I think I'd give that advice irrespective. If I was in that position, I'd be doing exactly the same thing.
As a layperson looking from the outside in, it makes perfect sense to me, because common sense tells me that there is this company that you're working for. It's a very well resourced, well funded company. They will have created those agreements with the help of experienced employment lawyers and an entire HR department, for example. And so it's only fair upon yourself that you go off and seek similar ability when it comes to sort of representing yourself and your interests. So it does make a lot of sense. Lee, that's really useful. Thank you again so much. That's fantastic.